All right, next on our list, we have the approve the rule changes proposed by the Court Rules and Procedures Committee. Subcommittee Chair Claire Carden will be presenting on CRLJ 17, CRLJ 56, and CRLJ 60. And then I understand Chair Rivas is presenting on Evidentiary Rule 413. So our presenters here?
I'm here, yes.
Ms. Carden?
Rivas, I'm also here.
All right, Mr. Rivas, thank you. It's a little hard to see with so many different little boxes here on two different screens.
Sorry to interrupt, this is Rex. Kyle, President Cicchetti, can you turn your volume down on your end? It seems like your audio, there's a little feedback happening.
Turn my audio down. How about that, Rex? Does that work better?
Just there's a little hum when you speak. Maybe it'll clear up.
I think that could be my next door neighbor, as I mentioned. There is some machinery going on outside. All right, I'll try to mute as much as I can. All right, let me turn it over to Chair Carden to talk about the CRLJ rules and the proposals.
Thank you. We have three proposals for the CRLJs. None of them are substantive. It is designed simply to bring the rules in line either with other court rules or statutes. Starting with CRLJ 17, we are suggesting changing all references to insane or incompetent persons to incapacitated. That just makes the rule consistent with the language of RCW 408060 and modernizes the language to make it less offensive. Looking at CRLJ 56, we are suggesting removing all references to he and changing those to the party. This makes the rule consistent with CR 56 and allows for easier understanding. Specifically, there was only one mention of he, and it was extremely confusing as to who the he was. And finally, CRLJ 60, the last two sentences of CRLJ 60B11 actually reference all of CRLJ 60B. So we're suggesting separating that to make it clear it does not just apply to B11. Does anybody have any questions?
Hold on, I've got to get off mute again. All right, so with that, thank you for that presentation. Participants, I'm going to open it up to the Board of Governors. Does anyone have any questions about what sounds like three pretty good amendments that would improve our consistency and readability of the rules? Not seeing any hands. Thank you, Chair Carden. I appreciate that. Let's go ahead, before we move on that, we'll go ahead and hear from Chair Rivas, and then after we've heard from him on ER 413, I'll entertain motions.
Thank you very much, Mr. President. I was wondering, actually, I just had about 5 or 6 slides just to kind of show the changes I'm proposing on ER 413. Would it be possible to enable screen sharing? I don't know if that's...
Yes, I just did that for you.
Excellent, thank you. Let me make sure I am, okay, here we are. All right, so this is a change to a proposed amendment to ER 413. ER 413 is a fairly new rule. It was adopted in 2018. It was a joint submission to the Supreme Court by Columbia Legal Services, Northwest Immigrant Right Project, Legal Voice, and the Washington Association of Prosecuting Attorneys. I believe that was a direct submission to the Supreme Court. It didn't go through our committee. And the purpose of this was to make evidence of immigration status generally admissible with only a few narrow exceptions, which are spelled out in the rule. rule. And the fear was that the integrity of the judicial process was sometimes compromised because litigants or witnesses would be worried about coming to the courthouse for fear of their, they would be subject to cross-examination or evidence about immigration status. And so this basically takes that off of the table, except for a few narrow exceptions. And that was the purpose of the original rule. Our proposed amendments just do two technical changes. One is to subsection A, which deals with criminal cases, and the other is to subsection B, which is civil cases. And in both cases, the purpose of our proposed amendment is to bring the text of the rule in line with the purpose of the rule as expressed in the original GR9 cover sheet. We felt there's a bit of a mismatch in these two places, so we're just aligning the rule with what its stated purpose was. So for the criminal case, subsection A, the stated purpose, and this is the part that we focused in on. Actually, this is specifically subsection A5. It was described on the original cover sheet that this subsection clarifies that subsection A shall not be construed to prohibit cross-examination regarding immigration status if doing so would violate a criminal defendant's constitutional rights. But what the actual text said is nothing in this section shall be construed to exclude evidence that would result in the violation of a defendant's constitutional rights. And we felt this was a little ambiguous because it makes it sound like the rule didn't operate to exclude evidence that would result in a violation of a defendant's constitutional rights, when really what this is clarifying is that the rule doesn't exclude evidence if that exclusion would violate someone's constitutional rights. I mean, obviously, if evidence would violate someone's constitutional rights, it probably shouldn't be coming in anyway. So we amended that to, we think, better bring that in line with what the cover sheet said. So nothing in this section shall be construed to exclude evidence if the exclusion of that evidence would violate a defendant's constitutional rights. And the next subsection, B, dealing with civil cases. Again, the cover sheet said subsection B1 sets forth two limited circumstances where evidence of immigration status would be handled through a CR 59H motion. The text of subsection B1 specifies we're talking about post-trial proceedings, and it gives two limited examples of the sorts of proceedings where immigration status could be brought up, but it doesn't limit it to CR 59 as the GR 9 cover sheet indicated was the intent. CR 59 isn't the only rule under which you can bring post-trial motions. CR 59 motions are, within a fairly limited time span, I believe 10 days after the end of a case. A CR 60 motion could be, a year or even more after a case. So we felt that we should specifically bring Rule 59, and we included CRLJ 59 as well as CR 59 into the text of the rule, just to specify that really this is a narrow exception, which was the intent of the original rule. I believe it's made a mention in our submission, the materials we submitted, that we did receive a comment from when we put this out to comment. Someone was asking if it was the position of our committee that immigration status would be inadmissible in child custody cases. That really was beyond the scope of what we were looking at here, which was, I think, speaking personally, I think it's a fair reading of both our amendment and also the original rule that immigration status wouldn't be admissible in a child custody case unless it fell into one of these exceptions. But our change isn't meant to enlarge or contract the scope of the rule beyond what it already was. So, are there any questions on this?
Thank you, Chair Rivas. Let me ask a question, and forgive my ignorance. I don't practice in the area of criminal law, but can you give an example of when exclusion of evidence would violate a person's constitutional rights?
Well, there would be, for instance, the Sixth Amendment right to confront witnesses against you, and part of that would be testing their credibility through cross-examination. So, if, for instance, someone's immigration status would be in some way something which would bear on their credibility. For instance, it would conflict with testimony they gave, and you would want to be able to confront them with that. That would be an instance where your Sixth Amendment constitutional right to call into question the credibility of a witness regarding their testimony would be affected if you couldn't ask them that question. And there would also be other instances where, if, for instance, immigration status is an element of the offense which is being proved. That's another exception, which is not in the part that we dealt with, but that would be another instance where the evidence would be admissible under the rule.
Thank you. I'm looking to my little blue hands for any governors that have questions. Governor Pertzer.
Right, thank you. Mr. Rivas, I guess I'm a little curious, why is it that you believe that you need to make this rule at all when evidentiary issues are basically governed by the evidence rules? And so I'm not sure the specific purpose, and the reason is that I reason is this, is it seems to me like you're kind of limiting immigration status to a particular area when in fact that might be counterproductive to what you might want to do. So if you could kind of comment on to why you don't think that the evidence rules themselves, for instance, evidence rules 401 through 403, why that would not cover, and 404 itself, why that wouldn't cover what you're trying to do here?
Thank you for that question. Just to clarify, this rule is already on the books and has been since 2018. So, I mean, what we're doing right now is trying to, I guess, make minor technical tweaks so the rule as it exists on the books matches what it was supposed to do. I mean, speaking just from personal experience, or at least second or third hand personal experience, my wife does a fair amount of work with victims of domestic violence who are petitioning for civil protection orders. And it is very run of the mill that if they don't have legal status, that fact will have been held over them sometimes for years as, you can't go to the courts because, I'm going to get you deported, as an example. So this is a sort of thing where simply specifying that unless there is a good reason, and the rule as it exists does have several limited carve-outs. The fact that immigration status has been, I guess, consistently wielded as a threat or something without necessarily a valid litigation purpose, that even when that isn't specifically threatened, the fear that it could be is keeping people away from the courthouse, either as litigants or as witnesses, irrespective of the merits of the actual claims being litigated.
Okay. All right, thank you.
Thank you. And just as a reminder for folks viewing the chat, due to the OPMA, we can't have substantive discussions in the chat. So if you would refrain from that. I will, however, open this subject up for public questions, and I'm not seeing any other governors. So I do see Hawkins. I recognize you, Ms. Hawkins.
Thank you, Kyle. I just wanted to say that when I saw this in the materials, I forwarded it to our executive committee that's meeting tomorrow for us to potentially take a position on the question that was asked about the child custody issues. So to the extent that we develop a position that we want the Board of Governors or anyone else to know about, we'll forward it after tomorrow.
Certainly, thank you for that. And I mean, we would certainly, as a committee, be open to considering, changing the scope of the rule one way or the other. But in this cycle, all that we're recommending was, as I said before, technical fixes.
And let me ask you this, Chair Rivas, are you under a deadline for having this this amendment pass the Board of Governors?
No deadline. I mean, I think, our view is, since the rule is on the books now, whether or not it changes further in the future, we felt that at the very least it should, be clear about what it is providing in relation to what it was supposed to provide.
Understood. Thank you.
Thank you.
I'm on mute again. Okay, I'm looking at my participants again. Governor Grabicki, you have a question.
I was going to move that we move these rule amendments on to the Supreme Court with our recommendation.
All right, I have a motion. Do I have a second?
A second.
Is that Governor Dresden? All right, I have a motion from Governor Grabicki. I have a second from Governor Dresden. Any further comments? Not hearing any. I'll proceed to a roll call vote. Governor Aba. Governor Angevel.
Aye.
Governor Boyd.
Aye.
Governor Clark.
Aye.
Governor Dresden.
Aye.
Governor Grabicki.
Aye.
Governor Higginson.
Aye.
Governor Kang. Governor Knight. Governor Knight. You may be on mute, Governor Knight. Governor McBride.
Aye.
Governor Peterson.
Yes.
Governor Pertzer.
Aye.
Governor Williams-Ruth.
Aye.
One more time, Governor Knight. All right, we have 10 votes yay, yes, no votes, and no abstentions. Thank you so much, both of you, for presenting today. And it looks like you're on your way for your next step. We wish you luck and appreciate your thoughts and consideration.
Thank you very much for the opportunity to present. Take care.
Thank you.